Good morning, everyone, and welcome to our webinar called the Great Smash and Grab Fight, which clues in the name is all about smash and grab adjudications and the scraps that occur during them. So just a quick introduction as to Archer. That's a photograph of all of our faces. You've got the 6 partners along the top, and then all the rest of us underneath. Archer is a specialist construction law firm, and we cover all ranges of construction law, from development and non-contentious work to disputes, which includes adjudication, the subject of this webinar.
So before we come to the main event, I just thought I'd get you all pumped up. So
from Las Vegas, let's get it to rumble.
Yeah, I can't help it. I've got a bit excited. You'll be able to tell from the slides as well. And also you'll be able to tell which generation I'm from the boxes. Anyway,
we've really lent into the boxing theme here. So, okay, as a quick preview of what's to come, we've got a brief introduction into as to who Andrew and I am, and our chosen boxers for the webinar. A quick introduction as to what a smash and grab adjudication is for anybody that doesn't know. A roundup of the key smash and grab case law pre and post 2011, which is when some key changes were made to the Construction Act. Then Andrew and I are going to slug it out for 12 rounds using a fictional smash and grab adjudication scenario with reference to relevant recent case law. And at the end, as a debrief, we're going to sort of tie it all up and give some practical tips for people on both sides of the smash and grab equation.
So I'm a southpaw flying out of New York. I have a record of 58 smash and grab adjudications, 24 wins, 24 technical knockouts, and 10 losses. I've just made those numbers up. I've been doing this a long time. I also, if I just press that, I just go down one. That is actually a true picture of me at the gym. Ivan Drago from Rocky 2, I believe. I'm an ex-engineer and do a lot of smash and grab adjudications, and was involved in ISG and CVIC for all that. I knew we should have won, but we didn't find out until 5 years later. So that's me.
Okay, and I have a slightly less illustrious record, but I qualified as a solicitor probably about 2.5 years ago. Prior to that, worked in construction, in commercial roles in the construction industry, and for the purpose of this webinar, I will be embodying Barry McGuigan, who, at least according to Google, is small in stature and has a relentless and hard-working style. So that's the traits that I'm taking on as a smash and grab payee. Okay, so a brief introduction as to what a smash and grab adjudication is. Effectively, it's a technical adjudication based on a procedural default, and that's the paying party's failure to serve a payment or a pay less notice. And it accords with the policy that underlies the Construction Act, and that's effectively pay now, argue later. And you'll see that theme come out in some of the cases that we're going to speak about later. A smash and grab adjudication can also arise when, and you see this sometimes when, for example, a paying party has given a payment or a pay less notice showing a sum due and still not paid it anyway. The principles are broadly the same. If anything, that makes things a bit easier because you've effectively got a document from the paying party that an amount is due, even though they've not paid it.
I think it's over to me, I think. So the ropes have been loosened, the trash talking is done. We're at the weigh-in, and I actually do weigh the same weight as a super heavyweight, at least on the bottom of that class. I think Liam came in as a lightweight, I think, from memory. But anyway, pre the new Construction Act, for those of you old enough to remember, we had a slightly odd scenario where if you put in an application and it was certified and there was no withholding notice, then the courts have decided in a case called Rupert Morgan and Jervis that there was no defence to that. So effectively, you had no right to defend that, saying the sum was incorrect. If it had been certified and you hadn't issued withholding notice, you could, no one called it that at the time, but you could do a smash and grab adjudication. Where it was different to what it is now is the case of SL Timbers and Carillion. Now, SL Timbers put in an application which wasn't certified by Carillion. I think it was that way around, whichever way around it was, yeah, it wasn't certified. Therefore, there was an application without a certificate. Now, the court in that case decided that that was not an amount due, and you couldn't effectively do the equivalent to a smash and grab. So you had this situation where it was actually the payer's benefit to say nothing, because in that case, you couldn't do what was then called a smash, or what then amounted to a smash and grab. So that was effectively why the new Construction Act, at least in part, was introduced. Now, the kernel, the key issue here, and I'll say the kernel again because that is Manny Pacquiao, who's turned into a colonel in the Philippines, yeah, I think. So the kernel of it is 110B4 in the new Construction Act. And what 110B4 basically says, and if you can't read that, feel free to go with that. What 110B4 effectively says is, if someone puts in an application and the other side does not issue a valuation or certificate, otherwise known as a payment notice, then the application becomes the sum due, and in the absence of a pay less notice, the sum is payable. There's no defence to not paying it. So that's the difference between the new Construction Act and what the position was under SL Timbers. So if there is a valid application, you can now do a smash and grab. So this is after 2011, whereas pre-2011 you couldn't. If we go on to the next slide, Liam's getting carried away with someone who's just said it's always good to see a reference to Barry McGuigan.
I'll take that as well.
So how does JCT deal with this? In very simple terms, it has a clause that actually says it. It says at 410(1), a contractor can make an application. And at 410(2), it says if an application is made and there is no certificate, this is the JCT standard, if there's no certificate, then the application becomes the payment notice, so effectively reflects 110B4. So if you put an application in, and it's a valid one, it will become the payment notice. Slightly different to JCT D&B. Ultimately the same principle, but D&B is an application-led process, whereas JCT standard is a certificate-led process. But the principle is the same. You put in an application, it's not dealt with, then you can bring a smash and grab. NEC, I have to say, as is sometimes normal, isn't massively clear on how it deals with 110B4. So it enables the contractor to issue an application, 50.4, and the project manager's certificate is classed the payment notice and becomes the notified sum. There is no provision specifically saying that if you don't get a payment notice, the application becomes the sum due. I think what NEC is doing is relying on the sort of act itself. NEC as normal is not perhaps as helpful as it could be. Fundamentally, though, if you put in an application under NEC and there's no assessment / payment notice, certificate, whatever you want to call it, and no pay less notice, then you can bring a smash and grab. And just on NEC, it works both ways. So you can have a negative payment notice as well as a positive. You can't on JCT.
Okay, so the default payment mechanism that Andrew mentioned in the new Construction Act a few slides ago sort of spurred a string of case law where, in effect, it's the regime that we all know now, where you can put in an application. If there's no payment notice in response, you've got a notified sum that you can smash and grab on. The sort of high point of that string of cases, and this will sting for Andrew a bit, is that is ISG and CVIC, and in that case, ISG put in an application, no response, notified sum arose, and the court said in that case that in that situation, an employer was deemed to have agreed the value in the notice, even though it arose on a sort of default basis. Another case after that, Gulliford Trine Estura, it followed the same principle in ISG, i.e. the employer was deemed to have agreed the value, but on enforcement, the court only enforced 1.5 of about £4 million of the decision due to what it called a manifest injustice if it would have done so. So I think the court said something along the lines of if they'd awarded the whole £4 million, it wouldn't have sort of induced the contractor to come back to the job, and the partial stay was how they got around that. S&T and Grove is quite a well-known case, and in that particular case, what you might call the ISG principle was watered down in the sense that the court said, yeah, you can smash and grab, and once the paying party, in this case the employer, has paid the notified sum, they can then start an adjudication effectively to determine the value of that particular payment cycle.
The key point really with ISG was that you had to wait until the final certificate to get any money back. S&T have said, and it's got more complicated as Liam's about to come on to, but S&T and Grove said, well, you don't have to wait till the final certificate, but you do have to pay it first before you can bring it back. So that's how it watered down ISG and CV. This thing is constantly changing, as Liam said.
Yeah, AM Construction, the top case there, the court decided that for the sort of Grove principle to apply, the payee doesn't necessarily need an adjudication decision on the notified sum. Just the existence of a notified sum that hasn't been paid is enough to prevent a true value adjudication until payment. So that's quite a powerful tool, I suppose, for a payee who doesn't have an adjudication decision and hasn't been paid, to prevent any true value adjudication. Hendry and Alufix, that was a case that one of my colleagues here did. So I'll do my best to kind of relay it because it's quite complicated. So there was a termination of the subcontracts. The subcontractor started a smash and grab adjudication, and in the middle of that adjudication, our client, the contractor, started a true value adjudication. The true value adjudication was stayed pending the outcome of the smash and grab, and our client ended up losing the smash and grab, paid the notified sum, and at that point recommenced the true value adjudication. The court ended up deciding that the true value adjudication, albeit it was stayed and the notified sum was paid during it, was ineffective because at the point that it was started, the notified sum was had crystallized and at that point was unpaid. That, like I say, that was a case that concerned a termination payment, so the final payment under a contract. So you can sort of follow the logic there, but if you apply that logic to a contract that's ongoing, I don't know how far back that principle extends. So is a payee, for example, entitled to refer to a notified sum that's 5 cycles old to prevent a true value adjudication on the current cycle? It's perhaps that's something that needs to be shaken out with following case law. Okay, so now we're into the main event, and this is mine and Andrew's fictional boxing match. So round one, and for the older viewers, that's Rocky Balboa or Sylvester Stallone. A smash and grab adjudication situation all starts with a valid application, and according to the Construction Act, the bare minimum that you need is effectively a net sum due and a breakdown of that sum, which I think is quite a low bar to meet. Hennier and Beck is a case that says that applications should be valid applications in form, substance, and intent, and effectively that means that it needs to look like an application and have the content of an application and be free from ambiguity. So I think a key point there is, if it's a payment application, call it a payment application and not a valuation, not a draft projected final account or anything like that. Call it what it is, and avoid the ambiguity. RGB and Tor, that was a case that effectively reinforced the requirements for reinforced the need for an application to meet the contractual requirements. So if the contract says, for example, you need to send applications to applications@contractor.co.uk, that's what you do, and anything else risks them being not valid, and you won't be able to rely on them later on.
I'm going to do that for 12 rounds, so I apologise in advance. So we've got the application. So I'm the payer. What can I do? For those of you of a certain age, that's Hendry knocking down Muhammad Ali in the 60s. Then all of a sudden, Muhammad Ali had a split glove, managed to get 5 minutes rest, and then beat Henry to a pulp. But anyway, that's for the older viewers. Right. So you've got an application. As a payer, you're going to allege that that's invalid due to lack of substantiation. There's not enough detail for you to understand how that comes about. Now, what you will find in the case law, and it does really, case law and adjudication, and I'll come on to this right at the end, it really just depends who you have, but there is a sort of overriding view that there shouldn't be any slavish compliance with sort of process. If it's good enough, then it should be treated as good enough. A good case of this is Kirstfield and Bray and Slaughter, which is a sort of the application was not particularly clear, but the court said a lack of substantiation would not invalidate the application itself. It's a very interesting case because you've got the other side trying to issue a pay less notice. They issue it 10 minutes out of date, then you get a sort of weekend, and all of a sudden the pay less notice is late. Then they're trying to argue the application. So the first thing that a payer can do is argue that an application is invalid due to a lack of substantiation, a lack of compliance and stuff. But it's not straightforward because the courts are keen to enforce something that everyone knew was an application.
Okay, so round three, I put my valid application in, and then Andrew sends me what he describes as a holding payment notice for £1 with a covering email that says he's off out for lunch, and at some point later on during the week he'll send me the proper payment notice. A very similar situation happened in Downs Road and Laxman By, where I think the contractor applied for about £600,000, and then the employer sent a holding payment notice for £1 less 3p retention, so 97p. And then it's sort of second payment notice was sent later on. The court ended up finding that a sort of one-line holding payment notice isn't invalid, for a start, because it didn't have the breakdown of the sum due. There was also a bit of a debate in that case as to whether a party needs a genuine belief in the contents of an application or a payment notice for it to be valid. And that didn't get a huge amount of attention in the case. I tend to think that if, as a contractor or a subcontractor, your application includes enough detail in terms of the breakdown, commentary on claimed items and substantiation, the genuine belief point shouldn't come up. But I think the less detail that's in an application or a notice, the more chance that the genuine belief point has got of gaining a bit of traction.
Before we skip to round 4, the 2 points. That's a picture of Joe Bugman. So he was a sort of gimmicky type boxer, hence and there was a logic behind that because it's the £1 notice is a gimmick type. But as Liam says, that the genuine belief point is actually coming out more where, as a payer, you turn around and say the application, there was no genuine belief in the application itself. So, classic example would be an exaggerated loss and expense claim in an application. You would be able to argue that the payee had no genuine belief in that sum, and so down the road and Laxman bias almost. It's not the £1 notice because that was never going to be good enough. It's a genuine belief point that has been taken on a bit more in the other case. Round 4 now. If you like Barry McGuigan, you'll like this one. It's got 4 of the best fighters of their time. Also, the interesting fact about Marvin Hagler, who actually changed his name to Marvelous Marvin Hagler. So I am now Awesome Andrew Rush rather than just who I am. We've also got Thomas Hitman Hearns on there, Roberto Duran and Sugar Ray Leonard. Those are the days for those of us of a certain age. So what you've got here is, can a payer effectively undo missing a payment or pay less notice by issuing one later and arguing it covers the one before? Now you've got an interesting case called it's a joint venture called Advance, which was actually Balfour Beatty and MWH Treatment Limited. So it's not just the small contractors that get this wrong. You had a payment schedule where actually the date of pay less notice could be issued for application 25 could also work for 24. So what you had was this Advance had missed, let's be honest, application 24. Comes around to application 25, they issue a pay less notice and then try and argue in the adjudication that the pay less notice they issued for application 25 also counts for 24. The timing was fine because of the way the payment schedule worked. The actual pay less notice expressly referred to application number 25, not 24, and some bizarrely inadvertently referred to application number 17 as well. The parties seemed to agree that number 17 was just a typo. So what the court had to decide was, could an application that was labelled, could a pay less notice that was labelled for one application because of the timing be applied to the previous application? And the simple answer was no. It's got to be on its face dealing with that particular application. So whilst it was okay for application 25, it couldn't be used to rule out application 24. And there is this general theme throughout the case law that, if it says it on the front of it, that's what it means. You can't try and argue it's something else. So from a payer's perspective, if you miss it, you can't really undo it at a later date.
Okay, so 3 days after Andrew sends me his holding payment notice and goes out for lunch, he then sends me a pay less notice, which is actually sent 3 days before, 3 days after the application is received, and therefore before the last date for a payment notice, which is usually 5 days after the payment due date. A similar issue came up in the case on the screen. It's quite a recent one, Place First and Car Construction. And I think there exactly the same thing had happened. The contractor had given a pay less notice only 3 days after the application was sent without sending a payment notice. And the subcontractor argued that was too early in effect. The court the court said no, and said that you can send a pay less notice at any point from the due date right up until the last date to send a pay less notice, and there's effectively nothing that says you can't serve a pay less notice before the date for serving a payment notice. So I think that gives paying parties sort of one extra way out in a sort of smash and grab situation. And just to sort of reiterate the last point on the screen there, the court did emphasise the sort of principle of substance over form when it comes to payment notices, and the court and therefore adjudicators won't be drawn into arguments about the sort of minor technicalities of payment and pay less notices, because I think the consequences of them being invalid are so severe, i.e. the notified sum rises and there's an entitlement to payment. And I think on the screen there is Frank Bruno and Mike Tyson.
Yeah, and for those of you old enough, you'll remember Harry Carpenter, got really excited because I think in one round at least, Bruno, he's hurt you, I think was his expression. Also, we just have a message from someone, harsh to call Joe Bugner a gimmick. I mean, it's a valid point, and I would not want to avoid for Joe Bugner, but I don't know whether the person who said that is South African or not. So, right, the next one. This is more modern day. What a great specimen Tyson Fury is. So, one of the things that we see and we keep seeing, and if you are on this call and you do have some terms that you go and check them, is that payers are working on the basis that perhaps correctly their terms apply, therefore they use their dates, and if they do comply with their dates, they'll be all right. The problem is that certain terms don't work, and the key one is if you link the final date for payment to an invoice. I mean, hopefully you'll know this, but Roachford and Kilham, and has subsequently been confirmed in a case called Little and 3CL, said you can't do that. Now, the simple truth is you should keep the reference to invoices out of payment applications, payment notices, and payless notices. It's not an invoice. Well, invoices themselves can be used as applications, but don't use an invoice once you've had an application as a means of assessing a date. And we keep seeing clauses that say, and this is just historic, and if people haven't revisited them, that say the final date for payment shall be 28 days after the due date, or after the provision of an invoice, whichever is the later, or words to that effect. Now, the problem with that is there is no certainty on a final date for payment because you've got a 28-day period or a different period depending on the invoice. Roachford and Kilham and Little and 3CL said that's non-compliant with the Construction Act, which means your 28 days becomes 17 days. It may or may not impact on other terms, other payment terms. So when you come to issue your pay less notice thinking you're well in time, you're not in time because your final date for payment is not 28 days or 45 days, it's 17 days. So you must check your terms to make sure that there's no reference to invoices triggering the final date for payment. It gets very complicated about whether it can trigger a due date and all this sort of stuff. It's best to sort of in the normal JCT world, you get an application for payment, you get a payment notice, you get a pay less notice, and the final date for payment is a set period after the due date. Don't trigger it back for an invoice.
Okay, round 7. So Andrew and I have been exchanging sort of the opening jabs in a smash and grab situation. I think him seeing the writing on the wall starts a true value adjudication. But as far as I'm concerned, there's a notified sum and that should be paid. This is the sort of situation that would give rise to a Hendry and Alufix scenario where, unless Andrew is abundantly confident that my notified sum doesn't exist and my smash and grab claims a load of rubbish, his true value adjudication might be sort of found to be a nullity later on, because that second adjudicator didn't have jurisdiction. That that then raises a few questions which maybe subsequent case law will tell us the answer to. But in that situation, it's difficult to know what Andrew is supposed to do, because without a confirmed decision either way on the smash and grab adjudication, he will never know if his true value adjudication is effective. So I think we might see case law that tweaks this principle later on. And also, as we said earlier, how far back does that particular principle go? Can a paying party use a notified sum that's 4 or 5 cycles old to prevent a true value adjudication on the current cycle?
Yeah, I think this question is the one that's left. And Henry and Andrew fix didn't really help. I've just got some notes on this. So you've got this situation where you're the payer and you've got a smash and grab adjudication that you think isn't going to win. So you might say, well, why are you worried about it? You just fight it, expect to win, etc., etc. But if you wait to start your valuation adjudication, you might find that you have to pay them. There's a longer period before which you can have your valuation adjudication. That party then goes bust. So you've got to ask yourself, well, can I bring a valuation adjudication? Now, what we've found is that if someone starts a smash and grab, you should be able to start a true valuation adjudication, because that is what the law says. You will find the vast bulk of adjudicators who won't take that on because they'll say they haven't got jurisdiction. But assuming you get an adjudicator takes it on, you could get to the end, win your valuation adjudication, but then the smash and grab comes in and they win, your one becomes a nullity. And now this does seem a bit unreasonable when you've got an actual decision on the true value, but that is overruled by a decision on a smash and grab. Now that is essentially what happened with ISG and CV. I know that a bit too well because I was actually doing it, but ISG applied for 1.1 million, had very little substantiation, and the adjudicator at the time, Bob Juniper, then decided the true value was 300,000. So you had two decisions. One was a procedural one, and one was a true value one, and that was the first time where the court said, "Well, you can't have the true value one." This does seem to be the sort of the elephant in the room about how we deal with this scenario. Where what do you do when you get a smash and grab adjudication and you're not sure it's going to succeed? What's going on to me? Right, this is for those of you from Norfolk, this is the great Herbie Hyde, who managed to win the WBO heavyweight championship of the world. I think WBO was like the 4th or 5th belt, but again, good old Herbie. So this one is about when applications from the payee are not on time. So you as payer confidently will write back and say, your application is 3 days too late, therefore we're not treating it as an application, and don't issue a payment notice or don't issue a pay letter or whatever you might choose to do. Don't do what I just said, by the way. Make sure you do issue a payment notice or pay letter. So you're sitting there thinking, well, they haven't complied with the contract, therefore it's fine. Well, Leeds and Waco, and there are some other cases on this, says that if in practice you've been accepting such applications throughout the life of the contract, then you won't be able to argue that in a subsequent adjudication. So if you haven't bothered issuing a payment notice or pay letter, or if you're going to try and argue that it's out of time, with the application itself, then you may find yourself on the back of a course of dealing argument and lose, even though they haven't strictly complied with the contract. So the real moral here is don't get into the habit of agreeing out-of-date applications. Be very sort of fastidious with making sure that if it's late, you say it's late. You can have a waiver clause, which I'll come on to later, which might help, but in itself, again, the courts don't like to say, oh, people can get off in circumstances where they've been operating in a way for month after month after month, and when it suits them not to, they turn around and say that doesn't apply. Not only have we seen the great Herbie Hyde, but this just makes it really difficult for a payer, because you don't know what to do, even if you have on the face of it an out-of-date application. Keep waiting for my bell.
Okay, round 9. So I think at this point, Andrew's seen that the writing's on the wall and pulled his true value adjudication and has thought, well, what I'll do is I'll just correct the valuation position in the next payment cycle, and that's an issue that came up in J&B Hopkins and Tron Engineering. And J&B Hopkins was the subcontractor, and in July 2019 it made an application which wasn't responded to, didn't do anything about it at the time, and carried on for the next 6 months or so until January 2020, at which point it started a smash and grab adjudication based on the previous July's application. Got a decision in its favour, and then enforcement in the TCC. Tron Engineering resisted enforcement on the basis that effectively the sum in the application had been superseded by the subsequent payment cycles, and the court partially agreed in the sense that it said that you could correct the valuation position in following payment cycles. So Andrew's tactic could in theory work, except that once a notified sum arises, you can still start an adjudication on that, even if it's been superseded by the following payment cycle. So we see this come up quite often in practice, that people want to refer a dispute based on historic notified sum. It comes up quite a lot. So it's just, I suppose, in the same way as the advance and Easter principle earlier, doing the right thing on the most recent payment cycle doesn't necessarily get you off the hook if you've not issued the right notices for the last one.
That was obviously Steve Bunce on the other slide. For those of you, this is Mohammed against Joe Frazier in the thriller in Manila. Again, that was 1973, I think. So and I was 3 years old at the time. What we have also found, this tends to be, I have to say, at the small scale end, that you will find someone who's owed quite a lot of money in relative terms, and they've had 4 or 5 applications not dealt with, no payment notices, no pay less notices. Do they have to bring each one separately, or can they bring them all at once? Now, I think the general view was thought to be that you had to bring them all separately, but Quadro and Creag has basically confirmed you don't. You've got, in that case, 3. They were invoices, but they were effectively their application. You have 3 invoices, and the court decided that the issue in question was a dispute about money, not a specific application. So you could bring more than one application on a notified sum on a smash and grab basis at the same time. So again, it sort of comes back to the point that if you've missed some historically, it's quite difficult to correct those. Clearly, if you've paid more than the sum they're applying for, that's a slightly different issue, but it's quite difficult to correct those. So Quadro and Creag does give the payee the opportunity to do more than one smash and grab application at the same time.
Okay, round 11. We're into the championship rounds now. So I've gotten at this point fed up with Andrew's posturing and think, right, okay, well I'm going to start a smash and grab adjudication now. Now to refer a dispute to adjudication, you need a crystallized dispute, and in very simple terms, that is a claim from somebody that's either expressly rejected or not responded to for so long that the dispute arises by implication. In the context of a smash and grab, there's not necessarily a need to crystallize a dispute beyond just waiting for the final date for payment to pass, and the case that confirms that is City Basements and Nordic Construction, it's on the screen, and the court effectively said there that in the context of a smash and grab, there is a crystallised dispute if the final day for payment has passed and there hasn't been any payment. In that situation, the payee doesn't necessarily have to write to the paying party and say, final day for payment's passed, pay up in 7 days or else. Interestingly, that's come up on a couple of adjudications recently, and despite the clarity of city basements, that's not a point that's understood universally by adjudicators, say. So I think it might sometimes be good practice to just write that letter and just formally crystallise a dispute before you start an adjudication to avoid the risk of it being kicked out on for a jurisdictional reason.
Round 12, the final round. I'm pummeling Liam with blows. He's panicked, and he decides that he can't rely on the smash and grab case alone, and he's gone for a true value adjudication as well at the same time. I should say, by the way, that that's a picture of Teofilio Stevenson, the Cuban boxer who won the Olympics 3 times in a row, but most people won't have heard of him. Anyway, can he do that? Can he bring a smash and grab and a valuation at the same time? And the answer is yes. Now, that I have to say, I don't agree with that, but that doesn't really matter what I think, because that's what the courts have said. But Coulson does say in Grove and S&T that a notified sum adjudication and a valuation adjudication are 2 distinct disputes. I don't see quite how this thing ties together, but you can bring a smash and grab and valuation at the same time, and you're effectively saying to the adjudicator, look, if you don't like, for whatever reason, the application, or you don't think it's complied, then please just decide the value anyway. We'll come on to whether some applications may be overstated, but if you haven't got an overstated application, there's nothing fundamentally wrong with doing that. But one thing you have to bear in mind is that if you bring a smash and grab adjudication, the other side, their only defence can be the application or the pay less notice was in time. They can't say you've been overpaid, give us the money back. If you bring a valuation adjudication, the other side have the right to say, I've overpaid you, you owe me money back. So that's another reason why you tend to err on the side of smash and grab first before you do a valuation.
Okay, so we've been through all 12 rounds, and now we need to work out who the winner is.
So, for those of you who are boxing fans, you will know this is a slide from when Roy Jones Jr. fought Park Si-hun in the 1988 Seoul Olympics. Roy Jones Jr. basically won this by a country mile and lost 3-2. Not least because 3 of the referees were paid off. Now, I'm not saying for a minute that adjudicators are paid off, but it does often depend who your adjudicator is, because some adjudicators are seen as being very anti smash and grab adjudications, and you can sort of see why. We'll come on to whether it's morally fair or not, but there's no certainty in this, and that works both ways, because as we've talked about with Leeds and Waco, you can quite categorically say, well, it wasn't in time, and an adjudicator can turn around and say, yes, but because of a course of dealing. So it's a bit like the boxing thing. You can never be sure of the outcome, even if you should be sure of the outcome. So it does tend to boil down to, on both sides, have you complied with the contract? What did you call it? What does it look like? What have the previous dealings been? Is that going to affect it? The answer is you can't be sure, and it does to a certain extent depend on your adjudicator. Okay, so the post-fight debrief. So we're just going to round up a few sort of practical tips for payees and paying parties. So from my perspective as a payee, a compliant and valid application is the key to a successful smash and grab adjudication. So things to think about are timing. When does your contract say that you can make applications? Is it periodic, i.e. once a month, once every fortnight? Is it on
certain events, milestones, for example. You might have got the foundations of a building in, got up to a certain level with brickwork, for example. Think about the format of your application. So I tend to call it an application to start with. Refer to the correct contract. If there is one, refer to the payment application clause and put the right date on it. In terms of substance, as we said earlier, the bare minimum is to include the net sum that you're applying for and a breakdown of that sum. And I think the most common way to do that is to have a gross valuation of the works less the amount that you previously applied for or being paid, and then that spits out a net sum due. Substantiation is ideal if you can provide it, particularly if the contract asks for it. But as Andrew mentioned earlier, that case, Kersfield and Brain Slaughter, says that it won't necessarily invalidate an application. I think it's good practice to include it, because if anything, it gives the paying party less wiggle room in terms of making deductions on payment or pay less notices. And then in terms of service, if the contract may or may not say something about where to send applications to and how. So if, for example, there's a specified email address in the contract, you should send it there. If it says to send it to a company's registered office by post or carrier pigeon, you should do it that way. And all of that is designed to make sure it's a valid application that effectively kicks this process off.
I think where you're a payer, I mean, we've got to a situation where failure to issue the right piece of paper on the right day can have enormous consequences, irrespective of the amount of work done. So it's tricky to say there's an easy solution to this. The key thing is if you're getting applications that are out of time, you should make it expressly clear that you may well be willing to value it, but you should make it expressly clear that it's not a valid application. You should definitely respond to it with a payment notice and pay less notice, even if you're reserving your position, because it's a bit like the Leeds and Waco thing. You may be perfectly right to say it's out of time, but there may be other reasons why an adjudicator decides it's fine. Do not get down the habit of issuing holding or draft notices. Do not send an email saying, I'll pay you 50 grand, Bob, and we'll sort it out next week. Because whilst you've paid 50 grand, the other 100 grand you haven't referred to will be recoverable on a smash and grab. If you are unlucky enough to get one and you think you're going to lose, think very carefully about paying and then immediately starting the valuation one to get it back. Obviously, that's a cash flow issue. It's also an insolvency issue, and so it's easy to say, oh, you should do that, and you obviously need to know what's going on with the other side and how realistic their sort of solvency is. So just try and stick to the contract. Don't get into the habit of doing it on the second Wednesday because Dave turns up on that day. Stick to the contract, otherwise it becomes it becomes uncertain, because you've got two options: either the contract or the way you've been doing it. So you don't want the uncertainty.
Okay, so in insolvency, we had a question before the webinar about insolvency and decided to add this particular slide. Can an insolvent company start an adjudication? Well, yes, in principle, and the case that decided that is Bresco and Lonsdale in the Supreme Court about 5 years ago. But there's been a string of cases after that which effectively say that, sure, an insolvent company can start an adjudication, you can get a decision, but the issues arise on enforcement, because effectively the court doesn't want to award an insolvent party money on an interim basis, only for that money to disappear and the other party to be sort of robbed of its ability to recover it at arbitration or in court or similar. So just a couple of those cases at the bottom, Malin and Volker Fitzpatrick, that was one of ours. We acted for the solvent defendant contractor there, and our client had a cross claim in enforcement that exceeded the value of the adjudication decision, and the court there gave a stay of execution, so effectively enforced the decision, but didn't make an order for payment against our client. John Doyle and Erith was another one where the court said that for an insolvent company to enforce an adjudication decision, it needs to give various forms of security. So, for example, ring fencing the judgment sum and giving the solvent party security for costs in any following litigation or arbitration. So, the bar for an insolvent company enforcing an adjudication decision is quite high.
And there's no relevance to the A squared plus B squared plus C squared. Well, it probably is some relevance, but I won't necessarily say what it is. Right, and we have quite a lot of questions. Yeah, we'll deal with the ones we've had. So I'm just putting down Ian is, well, I think it was Joe Bubner's love child, which probably is.
We've had a couple of boxing comments, but after those, we've got JCT contracts have a declared monthly payment application cycle. If a contractor makes an application outside of the agreed monthly application date, how would that affect the timescales for a smash and grab?
Well, if it's a D&B, your timescales aren't affected at all, because the D&B is the date the application is issued, and even if it's late, it's still a valid application if you're in D&B, because it's an application-driven process. If it's a non-D&B, I mean, subject to the timing of it, it's just not a valid application. But what you should do if you ask receiving those is you should write back saying this is not a valid application, but without prejudice to that position, we don't believe you're entitled to any more money than X. Therefore, you've dealt with the issue, but strictly it's not. You can get some very complicated scenarios where it might become a default payment notice, but in truth, just make sure you deal with it.
Okay, and then we've got a couple on a similar theme, and without reading out the amendments, they effectively amend the JCT final date for payment clause to make reference to issue of a VAT invoice from the contractor, and one of those people has said, "Do I need to panic?"
Yes. It's a simple truth, because you now have a set of terms. The problem is you can't just say, okay, let's ignore the invoice bit. You have a set of terms that are non-compliant with the Act, and there are various cases. But what the Construction Act does is remove the non-compliant payment provision and import the scheme provision. So your final date in that example will be 17 days, not 28. So you need to be managing that process means get your payment notice in on time, and if you want to issue a pay less notice, work on the basis of 17 days, not as the final date, and work back, and not 28, because otherwise, if you get into an argument, you will lose.
Okay, we've got one here. Scenario: payer and payee are circa 300,000 apart on evaluation. For the next application, the payee decides to send the application to someone's email who no longer works for the payer's company. The payer obviously misses this application, as that inbox is not monitored. Would that be deemed a valid application? Can this be smashed and grabbed?
Tricky, that one. If the email address had been used before, and the payee was not aware of that person leaving, then probably yes. And you can't. If you look at JCT, for example, it talks about notice provisions. They don't apply to payment applications. They only apply to termination documents. And if there's been a course of dealing doing this, then I think the answer is tricky. Now, you can obviously, as a payer, argue strongly that that was deliberate, but whose fault is it? Is it the receiving party's fault for not monitoring the email address, or the payee's fault?
We have a few clients who have central payment application inboxes, and that seems to be quite a good idea because they're always monitored by somebody. Whereas if you name, for example, a person, just one person in the contract as the person that valuations or applications should be sent to, there's a risk that if that person's has left or is off sick, on holiday, or using our earlier example on the golf course, then there's a potential to miss an application sent to that inbox. We've got time for one or two more.
Where employer is just issuing payment notices.
Where an employer is just issuing payment notices, albeit correctly served, but at sums far less than the application amount, with spurious reasoning on challenging valuations, then what can the payee do to protect themselves other than going to adjudication? So I suppose that's the classic kind of contra charge situation, isn't it?
I mean, the answer to that is, if you're being honest, you go to adjudication. You can't even suspend with any certainty, because you can't argue the sum's due because they've issued a valid payment notice. I say valid, I mean valid in form, and therefore, you can obviously challenge the value they've used with the other party. That your only solution is to go to adjudication. And it is immensely frustrating, and it is something that happens quite a lot, certainly at near to or post PC.
Okay, so well, we'll take this one last. It's from Jack. So if you issue your payment notice late and the payee raises an invoice to reflect the payment notice, have they accepted the late payment notice, or could they subsequently smash and grab based on the applied for figure? I would say they could smash and grab.
Yes, and I've got this on one where one of our clients has been almost too generous on his invoices. So it's a slightly different scenario, but similar in this. But he's applied for one figure, invoiced another, because he's taken the retention off the invoice, but hasn't had any payment notice or pay less notice. And our view is that he is entitled to the sum applied for. There's nothing in the Act that says any subsequent invoice overrides the previous. The truth is, as we've discussed already, invoices are something that should be avoided in payment clauses. The fact that in this case someone has issued an invoice, it's still the application sum that's relevant, not the invoice. Well, we normally don't get very many questions. Clearly got lots of questions, but this is clearly a hot topic. So we will deal with any questions that we haven't managed to get through today. I don't normally do this, but you know where we are should you have any issues. Hopefully it's been relatively light-hearted, and I think we'll put this down to a sort of outrageous draw with one judge losing his ball. And
isn't the modern trend to do a couple of rematches?
Oh, yeah. I suppose we could have a rematch, couldn't we? But thanks for your time.
Yeah, thank you.